Testing, testing. Can you? Is that going?
Should be on.
Wait, Brian.
Yeah.
Is that the right
There we go. There's Mike's. There we go.
Should be 4806140.
I'd like to welcome you guys to the Setzler Subcommittee. We're going to get started here in about 2 minutes. I had one member that's going to be joining us here in a moment, but got a 1 minute warning here. Let's start it. Ladies and gentlemen, I'd like to welcome you guys to the Setzler Subcommittee. We're taking up today Senate Bill 10. We have a committee substitute. There's been a couple subs. I was working off of LC 480607S. I think there's a 14S now.
That's correct.
So, so there may be some amendments that are tied to 0607. We'll work through that. But with that, I want to take some public testimony today. I want the author, who is the House sponsor of SB 10, to be able to speak to this and present the bill. There's a couple related subject matter that are in this. Sign-up list. Do we have the sign-up list established yet? Okay, we're going to put the sign-up list over on this side. If you guys can sign up, make sure you're signed up to be heard. And with that, Chair recognizes Representative Smith to present the bill.
Thank you, Mr. Chair. Good to be with y'all this afternoon. Today I bring to you the substitute for SB 10, LC number 480614S. And here in Section 1, this relates to amending the definition, or who is actually included as individual that is impersonated or impersonating an officer. And this would include an officer of the court. And so that would encompass all the attorneys that are before the court. That would also encompass the clerk of court and everybody basically involved in making our court system run. This was actually a change that was brought to me by a good friend of mine from down in the Columbus area that had an individual that was trying to impersonate her and cause all sort of trouble with the bar, and also have her committed to a mental institute because she was allegedly having mental issues. So I thought this was a good change to the law, that impersonating an officer of the court could be very detrimental to our system. We don't want that here in our state, and this is a move in the right direction. Section 2 of the bill, you'll see this was House Bill 905, and thanks to our great Chairman, Mr. James Burchett, and our great analyst, Brian Hines, we have narrowly tailored this language from what was originally presented to, I believe it was my subcommittee. And so you'll see here that this is concerning putting interception devices, surveillance devices in a clandestine manner, basically violating someone's right to privacy here in the state. And the code sections you'll see there that are cited, this is narrowly tailored to cover those with TPOs, protective orders, and consent orders, both of those first two code sections. And then code section 19-13A-4, that's the dating violence protective order statute that this committee has so diligently worked on in the past. And so that is Section 2 of the bill. Section 3, we go to the driver's license portion, as I've heard everybody talking about that. Just for the committee to have a little bit of background, basically, Mr. Chair, driver's license means a job. We don't have people riding horses to work anymore, hardly. And there's definitely not enough livery stables out there anymore for anyone to have their horse cared for. Maybe one day we'll get into loving horses more like that, but I digress. The most common way that a lot of Georgians lose their licenses is through missing a traffic court date. I've seen this firsthand in my practice. There's usually around 105,000 a year. And, you know, although I don't ever condone this, a lot of times they have to choose between going to court or going to work and risk losing their job. And sometimes it's just confusion. You have different court dates, and we see this in the pandemic especially. We have people that get several notices from the court, then they'll have their attorney notify them of the court date coming up. And it may be different dates. Something may have been rescheduled, and so they're confused as to which date they may need to go. But anyhow, this bill would allow the judge to have the discretion to reinstate that license. So really this is geared towards the defendant and helping make sure that even though we have someone that may lose their license, instead of just pouring salt on the wound, Mr. Chairman, we can have their license reinstated so they can continue to work, not lose their job, and generational issues don't begin by just the loss of a driver's license here in our state. So, Mr. Chairman, in essence, that's the Cliff Notes version. I'd be glad to discuss anything with anybody on the committee if there are any questions.
To the author, thank you. Are there any questions right out of the gate from members of the committee? Chair recognizes Representative McLaurin for a question.
Thanks, Mr. Chairman. Thanks to the author for the bill. I love so many things about it. Do you have a opinion on subject matter?
Which part? I'm sorry.
Do you have an opinion on it all being the same subject matter? Is it, what's the theory on that? Title 16 or what?
On driver's license being reinstated, or what? Could you clarify?
Oh, no, it's just this is the fun time of year when we, throw a bunch of bills together. And I assume that, I know the driver's license part was independent of the...
Yeah, there were several bills that our committee was considering, and we wanted to make sure that we put the good ones in here. We've worked a lot on this, and I think the representative will see we've changed a lot of that up that we didn't hear to make sure that it was narrowly tailored. Like 905, we thoroughly vetted that in committee, and the small changes in the other sections here, I think you'll see that this is not us trying to pull one here at the last minute. This is trying to make sure that we have good policy that actually makes it to Governor Kemp's desk.
Absolutely. Well, I agree it's good policy. It's just, the grand tradition of the Setzler Subcommittee. I wanted to ask the furthest reaches of questions that could be possibly asked. And
Sure.
that was the last one I had. So thank you.
Yep.
Are there any subsequent questions?
That was pretty substantive.
Further subsequent questions?
Yes, Mr. Chairman. Can you describe what stifling arrogance is? I've heard a lot of different types of arrogance before, but the chairman used in his remarks on the floor the phrase stifling arrogance. So I was wondering if the chairman could distinguish that from other types of arrogance.
I think the gentleman can distinguish satire and irony, and that's what sometimes we embrace. I would imagine you're familiar with that.
Thank you, Mr. Chairman.
No, I do believe I don't see from a subject matter perspective. You've got I don't see something here that jumps out as outside of the mainstream in terms of germaneness. I think the chair will make that ruling on the floor. I think from a committee perspective, I think it certainly satisfies my understanding of what's germane in terms of subject matter. So I appreciate that. Any further questions? I've got a couple for the gentleman, and then we'll take testimony. On line 16, officer of the court. Is there anything other than an attorney we're talking about there that meets the definition of officer of the court?
Those were all the individuals I named in addition to the attorney earlier when I presented the bill, Mr. Chairman, as you'll recall. But so just to refresh your memory, that would include the clerk of court as well.
Okay. I saw other public officer, I wasn't sure, or employee. I thought that was included in that, but okay, good. Okay. On line 51, 52, unless otherwise ordered by the court, there's some carve-outs I was trying to pull up in code. What is not included in this shall not apply to a violation of the DUI law. Is that one of it shall not apply there, or does this give the ability? Does this have any impact on the court if someone has a mandatory suspension of their license? Does this give the court a chance to not do that by discretion?
Not that I'm aware of, Mr. Chairman.
Okay, the code sections down below on 40-5-54, and what are those references where it does not apply?
Let me pull that code section. I don't think I have that with me.
And if there's anybody in the audience, this is a subcommittee, we can be a little bit less formal. Can anyone speak to that just briefly?
Yes, so Wade Askew from Georgia Justice Project.
Sure.
This bill would not affect those mandatory suspensions. This would only be if you have a failure to appear and that's the sole reason for a license suspension. Then in those situations, judge would have discretion to say, let's not move forward with the suspension in the interest of justice, or let's reinstate.
Are you signed up to be one of our speakers today? Do you have a question?
I'm not actually.
Because I may recognize you speak on mic so we can all hear that. Before I do that, though, is this our sign-up list here? Okay, I've only got one sign-up for 10. Okay, if you could grab that mic there, I'll recognize you from, does that say mic 1?
Mike one, that's right.
Okay, tell us who you are and give us your perspective.
Thank you, Mr. Chairman. Wade Askew, I'm the supervising attorney at Georgia Justice Project. And so,
Whoa. We have a new system here we're trying to understand and make it work. So, I'm just trying to understand this and unpack this. So, we're in 17.6.11. What's the operative language that tells us it would not apply more broadly than the circumstances you're talking about? What in this page 3 here would we kind of be the indicator that's the case? Okay, so I've got, just for those that are listening, 40-5-54 is homicide by vehicle, felony in the commission in which motor vehicle is used, hit and run, racing, fleeing or attempting to elude an officer, or operating with a suspended license. Okay, that's what that section is, and then 46-15. Okay, I get it. So if out of the gate you can get pop with it, it's not gonna, you can lose your license, it's not going to affect those. Okay, good. Got it. Thank you. Chair recognizes Robert Smith from PAC. No stranger to this subcommittee. Welcome. I've got a question for you about the underlying, one of these underlying issues. I had shared with the chairman, this idea of putting a tracking device on a car. Is law enforcement free to walk up to somebody in a Publix parking lot, Kroger parking lot, put a tracking device on their car and monitor them as they go about their business?
Not without a court order. I believe the name, I think the name of the case was Gardner. I could be wrong, but it was a U.S. Supreme Court case that held that to search. And law enforcement cannot search a vehicle without court orders.
In your mind, is it, my concern with the policy, and I'd raised this with some members of the committee, is that we're in subcommittee. We're not blitzing through in a sprint trying to get this done in as few minutes as we possibly can, and want to take our time here. I appreciate this protective order language. I mean, that sort of can stand on its own. I guess my concern was something that myself and actually former Vice Chairman Reeves had committed to on previous sessions and just got busy and just didn't get it done. It was just a legislative failure of me and Representative Reeves, was to put a protecting language in saying you can't just put a device on someone's car and track them. It's just really a very troubling invasion of someone's privacy. That broadening this, I know one of the things that have been raised to me by members of the committee was the concern that if my child is in your car and they're driving around, they're validly in the car, you're taking kids to a football game, that I can certainly track my child's phone and that kind of thing. So the idea of a tracking device in a person's possession who's then in a car should be trackable. I think we can all agree with that. I think I'm concerned we've narrowed this down with this TPO order, which is fine in and of itself. But as it stands today in Georgia, can an individual place a tracking device on a car? Can I go to the parking garage where your car's parked right now and put a tracking device on your car and track you as you go about your business? Is that legal today?
If you did it to me in your capacity as a private citizen, like a stranger on
Yep.
stranger situation,
Yes.
I don't believe it could be I don't believe you can do that. I think it would be, I'd have to look at the surveillance, the wiretapping statutes, and look at those. It's a bit of a round peg in a square hole, so it's not as clean as this language is.
I mean, I've got the statute right here. To me, it's in that would only be prohibited in any person commit any other act of a nature similar to those set out in 1 through 6. I think you'd have to catch it in the catch-all. That's my concern, is that there's nothing that specifically says thou shalt not put a tracking monitoring device on someone's car.
And the default is that if it isn't outlawed, then it's allowed.
Correct.
And that's why we need clarity in our law.
and there's case law that says law enforcement can't do it to a regular citizen. I think it's great that we're covering this TPO circumstance. But the broader question is, if law enforcement can't do it, and we believe that likely individual citizens can't or shouldn't be able to, why shouldn't we clarify that you can't, and then exclude the circumstance in which you're tracking a phone or some kind of tracking device that a person has in their possession that you otherwise could track? I mean, if Chairman Burchett's, if his kid was in a car with, say my wife was taking our kids and his kids somewhere, and his wife wanted to see through their Life 360 where the kids are, you could track where your kid is. That's not a device connected to my car. So I think I guess I'm thinking out loud, is there not value to allow folks to track people they lawfully can track, that being different than putting a device on a car?
I'm going to look at the language and, just kind of, my thought. It says it requires, and you have to intentionally want to track the person, and you also have to do it in a clandestine manner.
Mm-hmm.
If you tell your kids, I've turned Life 360 on, or some other Find My iPhone or whatever program, it's no longer clandestine. If you're, in your example you gave, if you don't have the intent to track the other people in the vehicle, that you accidentally get them, or you negligently get them, that doesn't rise to the level of violation of the statute.
I agree with that.
You have that says to intentionally do that. So if you intended on tracking a person, then go to this act. That's my burden, is I have to prove that the intended target is the person you were tracking, not an accidental victim.
Right. I agree. It's been raised, but I think it's so that's it would be a belt and suspenders to try to cover that. But Chair recognizes Representative McLaurin.
Thanks, Mr. Chairman. Let's get into section 2. Let's do it. There's some language order I'm concerned about. Intentionally and in a clandestine manner, when you place it there, clandestine manner or in a clandestine manner is going to modify direct, the verb, I think, most nearly. Someone else to place, which means that you're assigning the clandestineness to the direction. I think I'd prefer for it to say to intentionally place clandestinely or in a clandestine manner, or direct someone else to place in a clandestine manner, because I assume that that's the intention of that language. That's number 1. Number 2 would be lines 29, 30, or a protective order from another jurisdiction. Is the intention there that any type of protective order whatsoever from another jurisdiction would qualify, or are we trying to cabinet in the same way as the ones that are enumerated? That's a question for anybody.
So Representative McLaurin, when we were going through the language on this, we were looking at all the different states. There aren't exactly any that are doing it, as far as I've seen, are doing exactly like this, but there were references made generally about the protective orders from the other jurisdictions using similar language to this. The idea is to catch, general protective orders so that, if you have somebody out of state and they're stalking you, then presumably that protective order will still apply. So it's supposed to be, somewhat generalized and broad for that purpose.
Kind of has to be, I guess.
Yeah.
Okay. Okay.
One thing I would point out also is that the or direct someone else to place, that's already covered in another code section. Our party to a crime statute would pick that language up. So with the removal of or direct someone else to place would not impact the ability to prosecute or hold someone responsible that procures, hires, conspires with, all the language that's in our party to a crime statute.
Mr. Smith, I would love to see this type of zeal across the board when we discuss creating new offenses about what's already prosecutable. I think in terms of my comment, what I would just like to avoid is to have in a clandestine manner modifying direct, right? Because I think, you can imagine the crazy scenario where somebody goes out into a public square and yells to their friend, hey, can you help me track this other person's car? Then they're not within the purview of the statute, right? Yep. Thanks.
To Mr. Smith, and I have another question I want to recognize here in a moment. To Mr. Smith, do you see if there's a broad Do you see anything in the statute that creates a concern of businesses that have tracking devices on their cars? They could be implicated or caught up in this as, hey, this bill hurts my trucking company or my delivery company because now, people are going to use this as a way to say that I'm breaking the law by tracking I see zero of that. I want to get your affirmation that there's nothing in this that can implicate any kind of business for tracking their trucks and their vehicles.
And once again, get back to the notion that once again, it gets back to the issue of whether or not it's clandestine, and if your employer provides you with a vehicle, that's we all sign agreements when we rent a car.
Sure.
Those things are in there that we're agreeing to be tracked. We're agreeing, it's part of the business practices.
Great. Thank you. Chair recognizes Chairman Burchett for a question.
Well, this is not really substantive to this, but it is a pleasure to watch two future senators duke it out in the Setzler Subcommittee. So I just wanted to throw that in there.
I can only hope that's true. Long way to go before that's established fact. And I sincerely hope it's true of this gentleman as well. But thank you. I've got Mr. Smith. Anything else to raise about other parts of the bill that you had concerns about or wanted to add to?
No, sir. There's nothing else for us to. That's the only thing we're concerned about is the raising policy.
Will you run through that partition you were talking about? Sorry, Mr. Chairman. You mentioned the partitioning the language. Can you tell me how that works again?
Basically, what we were asked for is to take essentially all the underlying language and put that into a new subsection 7, and then take the currently existing subsection 7 and make it an 8.
Okay.
I think the nothing in this nothing in this paragraph section that modifies there.
I think you can phone a friend and I'll help you on that. I think if you look at the code section as it is now, basically we would just take that section 7 and change that into section 8, and we would strike from starting at look with me at line 31, starting with the word this. We would take that out all the way down to the period on line 33, right before the new language, starting with nothing.
You'd have to also go into subparagraph 6 and strike the or,
Okay.
and drop a semicolon in at the end of the new 7 with the or there. And I know that's the running joke about commas matter and things like that, but just to
Sure.
Chair recognizes Representative McLaurin.
Mr. Chairman, I think that was a legacy button push from earlier, but I do want to thank the chairman of the full committee for his emotional support.
Is there anyone else who wants to speak on the proposition? Anyone else on the measure? Anybody else? Okay. I'm going to share around some language. Could you share this with committee members? There's one for the chair. I think the chairman's got one. I'll share these, you guys. Could you share this with? Yeah, I'll hang on to this. Share that with folks in the audience and the other two committee members. It's just something I want to talk about. We're not in the position of taking amendments or anything, but I do want to talk about this language from a policy perspective. And I raised this as a question. It's one of the things I directed to Mr. Smith from PAC. Was, as he had alluded to, case law does not allow law enforcement to put tracking devices on individuals. And if law enforcement can't do it but with a court order, should individuals be able to privately do it amongst themselves? This is the policy effort that in a previous session we were looking to get through and just didn't make it across the goal line. and I wanted to just talk about it among members and just, again, in the spirit of subcommittee work, just discuss it, kick it around. Again, this was drawn as a broadening of the provision that's on lines 28 through 31. I'm not hostile to this temporary protective order language. I think it's fine. Maybe this stands in parallel to it, but I think because it's broader than that, I guess the question is, should we limit this prohibition on putting a tracking device unknowingly and in a clandestine manner on someone else's car to only folks with whom there's a temporary protective order kind of arrangement, or should it be a broad prohibition that you can't do it to anybody? And this is what I wanted to kind of just chat about with members of the subcommittee is, do we want to allow there to be lack of clarity today? I mean, as it stands, as PAC affirmed, it's not in keeping with what they understand to be lawful, but it's not clearly stated in statute the ability to say if the Oppo research against Representative McLaurin decided to put a tracking device on his car. They walked into a public parking garage here. They put a tracking device on your car, and the Oppo research firm just gets to track you through your entire life between now and the November election. Is that okay? And I mean, we can make all kind of jokes about this, but I mean, just in a very serious-minded way, should that be lawful? If law enforcement can't do it, should a private citizen be able to put a tracking device on the bumper of your car and just track you, and have your, they could. This is our, McLaurinogram. There's everywhere you go, they're tracking where you go. I mean, that could be true of people in a business setting. It could be true of people, students. It could be true of all kinds of folks. It could be true of even a stalker. If a stalker has an interest in somebody, to be able to put a tracking device and see where they go all the time. I mean, right now, what I hear PAC saying is it's not in the spirit of the law, but it's not clearly defined in statute that that's an unlawful activity. So I raised this question of the idea of this intentionally clandestine manner. Any person to intentionally in a clandestine manner direct someone else to place GPS, other electronic device on a motor vehicle of another person is a violation of 161162. And then the thinking was that's enumerated outside the context of the protective order, but you put in language that says this shall not include the tracking of a phone, personal communications device, GPS, or other electronic monitoring device in the possession of any person who is lawfully within the motor vehicle. Now, again, to Mr. Smith's point, that may not meet the definition of in a clandestine manner, but formally, this issue is raised of tracking people using the device that people have on their persons. And if that is a concern, this language was addressed to address that concern, that someone could claim that my wife was tracking them because my kid was in their car. And this would simply be an issue that they would say this can't be the basis of that. Life 360 can't run someone afoul of 161162. So I wanted to just tee that up, and I'd like to get the thoughts of the author and others.
Yes, Mr. Chairman, I think you've already seen as we discussed that amendment to basically take the present section 7 there, that's the catch-all. I think you'll see that will cover what you're wanting to do here. And the good thing is we live in a common law legal system. That's the great thing. We can do this through case law as those situations arise. So I think what you're wanting to do would be covered under that. And I would be adverse to changing that language other than what we had discussed with Mr. Smith, and thanks to PAC for that as well. Or excuse me, PAC and Gactel.
Well, let me ask you this then. If it's true that it covers a tracking device on any person, and we can take comfort in the catch-all.
I think a good lawyer could make that argument.
Okay, then the same lawyer could make that argument about somebody with a TPO relationship. There's nothing fundamentally different about the TPO conditions in which you've defined. That's actually a more narrow condition. That if in fact this catch-all protects you from being tracked by another person in any context, then for sure it protects somebody in this TPO context.
I mean, that can be the chairman's opinion on that. I don't necessarily would agree with it offhand. I think that's something we really need to look at and make sure that we prevent this specific situation. And you'll see that we have made sure not to encompass any more conduct than what we really want to here with the carve-outs there within that.
Does the gentleman recognize that the TPO situation is wholly contained within the conditions of a broader?
You know, that's the great thing about a common law legal system, Mr. Chairman. If we find some case law that is not doing what this committee would like for it to do, we can certainly come back, and I know you and the Senate would be willing to carry such a fix next year.
Chair recognizes Representative McLaurin.
Thanks, Mr. Chairman. Let's reconvene the McLaurin-Setzler axis on this particular point. I share the concern that there's conduct that needs to be prescribed while we're here. I share the concern that the catch-all doesn't adequately capture it. One question I have, and I'd love any input from the room, is whether the catch-all is void for vagueness. You know, I mean, it's a super big catch-all. It's a criminal statute, right? So, I mean, are we concerned that trying to apply it to the case that the chairman's talking about will get thrown out? Particularly, and I think it's an interesting hypothetical, kid in a car. You know, the parents intentionally tracking the kid in a clandestine way. That's intentional. And it has the result of intentionally tracking where the car is going. I think it's an interesting point. That being said, my sense of politics has evolved enough in 4 years that I don't want to piss off Tyler Paul. So I would not like to substantially change his bill. But I do think that it's an interesting public policy discussion to have, and for that purpose, the axis is reconvened. Thanks, Mr. Chairman.
Well, I mean, this is the time to talk about these things, and I share this. I mean, is it not enough of a concern that PAC raises the issue that it's unlawful for law enforcement to do that? And private citizens can do that. And the only argument you'd have against to the contrary is the catch-all, which I believe PAC affirmed is not something you could prosecute criminally. And if you can if you can prosecute the language criminally, then you can process the broader. If the broader condition is a policy place we don't want to go to, meaning we want people to continue to track things, then let's go there. Chair recognizes Chairman Burchett.
Thank you, Mr. Chairman. The common theme throughout this chapter or section 161162 is privacy. So what we're asking now to do is, as I understand it, you're not availed of any type of protection when driving out on the road. Jill, isn't that the case? And McLaurin could probably chime in here. I mean, if you're driving out and perfectly visible to everyone here, my nervousness is that now we're prescribing a protection of privacy now to just open public. When you're out driving around, you can be seen. I could follow you right now for no reason. And why would that be unlawful? And then secondly,
as could law enforcement. Law enforcement could follow you for no reason.
That's correct.
But case law says very clearly that they can't put a tracking device to track you.
Well, it also says that law enforcement can't walk in the front door, and people walk in other people's front doors all the time. It's called robbery, or burglary. So I mean, what I'm saying is this section deals literally every piece here deals with privacy. In a private place, private message, privacy of others. Let's see here, private place. And I'm not sure that you're in a private place when you're on a public right-of-way. I mean, I know you're not in a private place. You're in perfect view of everybody. So
why can't law enforcement put a tracking device on your car?
I don't think anybody's advocating for anybody to put law enforcement a GPS on a car.
Right, but if you're driving around the public highways and byways, law enforcement can follow you wherever they want to follow you.
That's right.
Okay. But case law says they can't put a tracking device on your car to to monitor you that way. They can follow you they can put unit number 6 to follow you around, but they can't put a tracking device in your car.
So be deemed unlawful search and seizure if you stick a GPS on there, Jill?
It's trespass. That's
Yeah.
the problem you should do.
So it's a trespass either way, right?
No, being out and about is, that's cats, that's in private places. And you can't think about that in the context of GPS monitoring. GPS monitoring is search and seizure. And that's how the Supreme Court distinguished it. But basically, the government coming on to your property and installing a device was a trespass, a criminal trespass, and therefore it was prohibited.
Castle
It wasn't
Doctrine.
that they were invading your privacy, it was that they were trespassing on your property.
Is it a trespass if I put something on your car?
Yes. Without my permission.
That's all I have, Mr. Chairman.
That's a search. This is U.S. v. Jones, 2012, landmark Supreme Court case. One of the benefits of being a young gun is you don't finish law school before it's decided, right? And it's a mosaic theory. Yeah, sorry, buddy. Process that. It's a mosaic theory, right? So it's different. I mean, the thing that's weird about this, and this is the scholarly debate for a decade or however long they have or more, is there's a difference between privacy, which is like opening a container, versus anonymity, which is the ability for your actions, words, whatever, not to be concentrated into information that's useful to somebody else or potentially offensive to you. Right? And so the problem is taking old school privacy concepts, which have been centered around containers that are either open or closed, to use a metaphor, and translating that into this type of an environment where following a car is not opening a container. And so if we really wanted to go down the rabbit hole, I think that would be a problem we have to solve. Again, you know, the Supreme Court's instinct, though, was that trespass theory or the mosaic theory is either criminal or unreasonable in nature under the Fourth Amendment. And so I think it makes sense from a public policy perspective to say we should deem it unreasonable under whatever theory to remove, and I would say anonymity is probably the more on-point concept analytically. But either way, regardless of how you skin it, I would agree with the chairman that that's the policy concern.
And it's the basis of, you know, that's whether it's you view it as Castle Doctrine, it's a search, or it's a trespass, and if,
Whether it's law enforcement or just a private individual.
right, and if law enforcement, who arguably, you know, law enforcement has some interest in it, individuals may have some personal desire. If there's a, why would we be more in jeopardy to a private individual trespassing when there's not? I mean, there's zero state interest in that. I mean, you could talk about the law enforcement state interest to be able to go knock on your door. Is everything okay in there? I mean, you could unpack some fact patterns that might make sense to the average person, but there's really no personal interest. And we don't go into this code section much. We're not in 1611, 62 very often at all. And I just thought, since we're creating new sections in here and carving this up, is this not time to go do that? I think this TPO language is great, but it seems if we're in here and we go in here about once every 5 or 10 years, this popped up a couple years ago in this committee, and we just never got it done. And it's, you know, I think the catch-all, it would be hard to bring a case. Maybe you have a super shocking fact pattern. You got a really, really willing jury, and a judge that sort of lets it hang out there that you could get a conviction. But I just don't know that most places, I mean, black letter law does not tell you can't do that. Clearly, in my mind.
If it's a trespass,
I mean, that we live in a common law system, Mr. Chair. I get what you're saying, but to do that would codify the law and would put us in the same vein as Louisiana. And I don't know about you, but I've looked over at Louisiana. Other than the cooking, I ain't been impressed much, even with the football team. But I would say this, though. You look at the crimes that we have, or the statutes that we have specified here, and I can tell you from actual practice in the field, there's some crazy stuff going on. Somebody's got a screw loose, and these protective orders are needed. And what this is narrowly tailored to, this, to me, would seem to be something that's going to protect lives. Now, I don't disagree that we can have that conversation. I'd be willing to when you and Representative McLaurin are in the Senate next year. But I think for now, and going back to what Representative Williams had in his original legislation, I think we have narrowly tailored this to prohibit the kind of conduct that Representative Williams wished to prohibit. And so he's been very helpful through this whole process. And so I'm amenable to that. It's just at this juncture in our 40-day session, I think that this being narrowly tailored, and I thank the chairman of the committee for his help in this. I think that to keep it the way that it is now would be the best position that is with the carve-out catch-all at the end.
Well, I would say parenthetically, I'm certainly not, as I said earlier, I have no issue with this TPO language being specifically there. I don't know that it doesn't need to be struck. We could go to 7, from 7 to 8, 8 to 9, and insert this. I guess the issue is, somebody that called a 3 o'clock committee meeting today at 11:45 this morning so that we can move this. I'm certainly not slow rolling this. I'm certainly not in a circumstance where I'm trying to slow this down and saying, hey, get this bad idea on this train, because otherwise it can't run on its own. I think we're not in this much, and I think we've got some time to take an inflection point and fix this. And so in my sense, my sense of this is that we not take this TPO language out. We leave this in, so there's an enumerated thing that speaks to TPOs. I'm asking the subcommittee, should we not also carefully craft something that says you may not put something on someone else's car, and it cannot be construed that tracking a device in the possession of a person who's in the car would get you caught up in that. I think we've got the time to work through those kinds of things. That's my concern, and I don't think it's going to take Representative Williams' bill down. I think there's great deference to what this committee does as a full committee, and I think they trust us to get these things right. And as I've told folks before, we're not writing laws for which there will be a, PAC and GACTL. They don't promulgate rules to interpret what we write. You pass a bill to the Education Committee, the State Department of Education, State Board gets to promulgate rules and flesh out the mistakes the legislature makes and some gaps that need to be filled in. We're writing black letter law, and I think taking time to do it's important. And I think we don't get a chance. These just can't get fixed by rule. Many sections in Title 40, many things can get fixed by rule. We've got to do it while we've got a bill up on the blocks in committee. That's my only concern. Chair recognizes Representative McLaurin.
Thank you, Mr. Chairman. I see one of two scenarios playing out here. The first one is my strong preference. That would be to move this with the small changes to fix it, clean it up. The House floor will be super, super green on that board, right? And then next year it'll be beautiful. Todd Paul Smith will get reelected, come back and stand there and say, simple bill, this House recognized the wisdom of this type of legislation earlier. We're just going to broaden it a little bit to cover some more circumstances. I'll yield for questions. It'll pass again. Super green, right? Second scenario would be that we fiddle with it and test fate in these last 4 days of session with a willing author and great legislation everybody's worked on, and we do a very small, bite-size add-on that says that you can't do this with regard to the exterior of any vehicle. Because I think part of the issue is, what if it's a phone inside the car? I think the line that makes sense to draw, if you're going to test fate and roll the dice here at the last minute, is to basically say you can't physically attach something to the exterior of a car in this intentional and clandestine way without consent. And I think that would be the line, but I strongly prefer scenario number one with two great well moments for Representative Tyler Paul Smith passing great bills.
Well, I just want to make sure we're not in a place where this still has to go to full committee. This isn't something that, and I'm not averse to being able to get conceptual agreement around things and offer amendments in full committee. I mean, we're working off of, sub here. We've got, I think we're going to have to make a change to this anyway if we're going to take the tact of splitting this out, where we create, we take the existing catch-all, make that paragraph 8 and we insert this, we're going to make a change to this anyway. So I don't think it's a hard change to make. This is just the time we're able to talk about these things. This is a doggone subcommittee. If we can't talk about stuff in subcommittee, when can we talk about things? So it's less about Robert's rules and more about deliberation, right? So just want you to get a sense of this. And I don't think, I'm looking for a forceful and clear reason to not do that as much as I am why would it be unwise to do it? We're not going to lose this bill because someone's going to make an impassioned floor speech against this. You shouldn't have had this broader tracking prohibition. I don't see that. Chairman Bichette walked to the well today and in 30 seconds secured unanimous passage of a bill, right?
Amazing.
No.
Yeah.
Good legislation.
So.
I'm thoroughly confused. I don't know if anybody else is. What are we doing here? Mr. Chairman?
Well, we're having a discussion around this broader policy question. I'm not.
I think that
And it doesn't have to happen in this subcommittee, but I want to get a sense of our.
as I understand what your argument is, basically that if it's unlawful for a law enforcement agency to put a GPS on a vehicle, then why not codify that it's unlawful for a private citizen to do that to someone else? Is that true?
Case law says it's a trespass.
That's right.
And if case law says it's a trespass for law enforcement to do it, one could argue that case law would make it a trespass for an individual citizen to do it. And if that's the case, to put a tracking device on someone's car in a clandestine manner, if case law says that, I think case law is clear about what law enforcement doing. I don't know that case law is clear about the private citizen doing that. If we believe that it is, why wouldn't we just codify case law? Because again, it's a trespass, and individuals can trespass much as law enforcement could. So I don't have to. The venue in which this happens could be a carefully constructed amendment offered in your full committee, and done that way. What I want to do though is I'm trying to get folks to a substantive agreement on the underlying substance. We're going to have to make a structural change to this anyway to renumber this. Can we get substantive agreement on that as a policy objective, and then have a committee sub or an amendment offered in full committee that gets that clarifies this underlying issue that I believe is flushed out in case law, but is not clear in 161162. It's a policy question.
Okay.
But I believe it's a policy question that most of us would agree, that shouldn't be so. And there's affirmation from the court to at least similar conditions. Should we not put that in statute in black and white, without slowing down any of what the gentleman's trying to do in SB 10? So that's all. So again, what I'm asking for is there any substantive disagreement that no, we ought to leave it as such that someone can put these devices on and leave that alone, or do we think it's better left vague so that courts can explore these fact patterns however they would, perhaps not in. Yes, ma'am. Yes.
After your conversation.
Ms. Travis.
The conversation you're having about potentially increasing this to any person anywhere as opposed to the limited language that the chairman has proposed would raise the punishment substantially. So I go out today and put a tracking device on Chairman Burchett's car. I'm guilty of trespass, right? If this passes and you open it up to everybody, I'm guilty of a felony of 1 to 5. And so I would ask you to not increase more punishment by putting it in that direction. And just so you're clear about the language change that that the PAC and I think needs to be made. Can I give you a proposed amendment?
Sure.
Strike on line 31. This also includes any person who commits. Move the language on lines 33 to 35 up to the end of the sentence where it says device. Make a new paragraph 8 that says any person to commit, which mirrors the language on lines 25. Any other acts of a similar nature, and I'm reading from line 32, of those set out in paragraphs 1 through 7 of this code section, which invade the privacy. So you're just returning it to current law. Thank you for letting me speak.
Chair recognizes Representative McLaurin.
Thanks, Mr. Chairman. I think we disagree about whether substantial revision of this code section will affect the likelihood of final passage. My assessment, based on my limited experience, it's not as extensive as yours, is that an amendment to broaden this right now would make it a lot harder to get some of the other things that we really like about this through this year. And that's just politics, but that's my guess.
Because of the felony treatment of this activity as opposed to a misdemeanor
I think
treatment.
for a lot of reasons. I think that's one piece of it. I think that, and look, I shocked Chairman Jay Collins on the floor today when I voted for a bill that, had bail in the title, right? So reasonable, right, I know. Reasonable people can think that some of this conduct should be prescribed. And I told you I'm with you on that. I think you've got the felony dimension to worry about. I think you've got the line drawing dimension to worry about. I mean, we've had 45-minute conversations on the floor after session's over about like drones and, the difference between privacy and anonymity. This is really hard stuff. And I think that Representative Smith's done a really good job taking the first bite with the protective order angle. I think in the context of the rest of the bill too, it's kind of, again, it's sausage making and it makes sense to just move it this way. I think trying to get that entire policy discussion right, nostalgic as I am for this forum, right, is probably gonna risk not doing what we want.
Okay, it's great discussion. Representative Smith.
I appreciate that from Representative McLaurin. I almost kind of think that y'all's party would be almost in favor of making invasion of privacy a felony to deter that kind of conduct. I know it sounds crazy, but it's something. And Mr. Chairman, I'm open to working with you over the summer on this, to looking at this issue as a whole, because I can remember in law school, and even when I find a case from time to time in practice, Judge Thurgood Marshall, and lamenting how privacy rights may or may not always be the number one priority of our conservative majority. They get it right on a lot of things, but I'm open to that. I think this is a good crack at it, starting out.
Okay. With that, what's the pleasure of the committee?
I'll make a motion.
Chair recognizes Representative McLaurin for a motion.
I think that this subcommittee should favorably report this legislation to the full committee.
Motion, do I have a second? Second, thank you. There's certain things that come after motions, right? Thank you. I appreciate that. Any discussion on the motion? Hearing none, all those in favor of sending it forward to full committee. As well, let me pause for a moment. I was in making the motion. You were moving the language with the structural tweaks that were framed by Ms. Travis and captured by staff. That was your motion?
Absolutely my motion, Mr. Chairman.
Thank you. Motion second.
Yep.
Discussion. Hearing none. All those in favor of sending it forward with a due pass recommendation, raise your right hand. It's passed, and we stand adjourned.